Here we'll explore the legal aspects of abortion, certainly starting with Roe versus Wade, but also some more recent legal decisions and laws that have been passed. So for Roe versus Wade, which was in 1973, the majority opinion was written by Justice Blackmun. And it was noted that the right to privacy is not specifically mentioned in the Constitution. It's not explicitly there, but it has been recognized as a fundamental right. So, for example, you have the right to do something in your basement, and the government has no reason to figure out what you're trying to do in your basement. If you want to build a pool table in your basement, you can do that, and the government does not need to know about it. Now, this is coming primarily from the 14th Amendment. Now, the right to privacy includes the abortion decision, according to Blackmun. The majority opinion says, look, just like the government has no reason to know what you're doing in your basement, the government has no reason to know what you're doing or interfere with what you're doing with your physician. Now, it is clarified that this is not an absolute right. So, for example, if the government thinks you have been building a nuclear weapon in your basement, that's a different story. If there are good reasons to suspect that, you're going to lose your right to privacy. And the state may also have interests that might interfere with the right to privacy, even in regards to an abortion decision. So that was acknowledged. The court tried to stay away from the issue of the beginning of life or personhood. Now, speaking of the beginning of life, it's not really a philosophical or legal question. It's fairly simple in some regards. Biologically speaking, when there is a zygote, there is a new life. It is a distinct being. It has its own genetic code and so on. During the early embryonic stages, even at 4 weeks, there are fingers and toes, and you don't say that a woman has 20 fingers because it doesn't belong to the woman. It belongs, the 10 fingers belong to the embryo, not to the woman. So it's a distinction there. Beginning of life is not really that much of an issue. Of course, there's a beginning of life. Now, the question of personhood is a rich philosophical question, and it could involve all kinds of things. Some philosophers have defined personhood in a way that a 1-year-old infant, or maybe even an 18-month-old infant would, or getting into a toddler stage maybe even, would not be considered a person, and neither would a severely mentally disabled person have those qualities that make someone a person. So the court at least tried to stay away from this issue. Now, there were restrictions then. The major push of Roe versus Wade, the major decision that was made, had to do with what restrictions there were regarding abortion in the state. So in the first trimester, the state may not restrict abortion. There, the right to privacy holds, regardless of what's going on. It's between a woman and her physician or provider when it comes to abortion. For the second trimester, the Roe versus Wade ruling declared that the state could regulate abortion, but this is an extremely important key here, for the sake of maternal health, the mother's health. That's the only case in which the state may regulate during the second trimester. For the third trimester, there the state, and I quote, in promoting its interest in the potentiality of human life, unquote, might restrict or even proscribe, that is, outlaw abortion. Now, this is kind of an odd phrase, the potentiality of human life, when they said they weren't going to make a statement about when life begins. to say something is potentially human is to say that it is not yet human in the third trimester even. But in any case, the idea here is the third trimester restriction, similar to the second, the state can regulate, only now it includes on behalf of the fetus. And so the state could restrict or even prescribe, prohibit abortion for the sake of the fetus in the third trimester, except, and the exception clause is built in here for Roe versus Wade, when abortion might be necessary for the preservation of the life or health of the mother. Now, the topic of health is significant, as we will see later. Now, the minority opinion when Roe versus Wade was written by two dissenting justices, and they argued that the decision gives too great of a latitude for reasons for abortion, that the reasons weren't restricted at all in the first trimester, and really not restricted for the second trimester as well. And so it seemed that abortions could be undertaken by what they called whim or caprice. They also argued that the 14th Amendment, what was appealed to for the right to privacy, obviously was not intended to restrict the issues of abortion, because there were 36 laws against abortion on the books when the 14th Amendment was ratified, and no one at that time thought it had anything to do with abortion. So the right to privacy that was in the 14th Amendment at the time of its passing, no one thought that it was relevant in any way for abortion. So it seemed to be a twisting, according to the minority opinion, of the spirit of what was going on, the intent. And here we could get into all kinds of concerns about intent of authorship and so on. We'll put those on hold. But those were not challenged for at least 100 years after the 14th Amendment was ratified. Now, since the Roe versus Wade decision, there have been significant United States Supreme Court decisions that are relevant for abortion. One in 1989 is Webster, that is Webster versus Reproductive Health Services, and it declared that the state does have a compelling interest in fetal life throughout the pregnancy, not limited to the third trimester, which is what Roe versus Wade said, so that the states may restrict abortions more broadly. So this opens the door for states to limit access to abortion for the sake of the fetus. And this is why the fetal development is significant when thinking about it. This is why that 8-week stage when you can detect a heartbeat and brain waves is significant in terms of the state maybe having an interest in the health and life of the fetus. Now, that does seem to conflict with statements in Roe versus Wade, but it was not certainly considered, again, not a repeal or overturning of Roe versus Wade. Another decision in 1992 affirmed the right to an abortion, and that's Planned Parenthood versus Casey. Now, along with affirming the right to abortion, it did allow states even more latitude in determining the age of viability. As we noted in the medical information on abortion, the age of viability is something that actually fluctuates according to medical technology. And so in 2019, the age of viability is in the around 25, 26 weeks. There is a 50-50 chance that the fetus would survive outside the womb with proper care. Even at 22 weeks, there is a 10 to 30% chance, somewhere in that range, of survival. And so the age of viability actually decreases the more medical technology is available. And we are currently developing ectogenesis technology, which would allow a fetus to survive outside the womb even earlier with an artificial womb of sorts, and that is likely in the future, so that it could be that someday a fetus at 8 weeks of development might be able to survive in an artificial womb. That would be long into the future, but it seems to be possible. Okay, in 2007, we had Gonzalez versus Carhart, and that upheld a federal ban on the dilation and extraction procedure. This was called the partial birth abortion by many people, the ones who identify as pro-life. And so there was a federal ban passed in Congress, and it was upheld in Gonzalez versus Carhart. And that is significant, a specific banning of that particular procedure. Now, recent state laws that are more restrictive have occurred since that 2007 and the 1989 Webster decision. And there are divergent trends going on in individual states. So some states have passed much more restrictive laws. For example, Missouri and Alabama. These might require things like an ultrasound prior to getting an abortion so that the woman can see the stage of development the fetus is at. It may require a supervising physician or hospital access for an abortion to be provided. Sometimes, often this is the case, abortion providers do not have a supervising physician at the facility itself. And so some of these states have required that that be the case. Other restrictive laws include prohibiting abortions after certain fetal stages, for example, detectable heartbeat, which is around 8 weeks, or having the capacity to feel pain, which, if associated with brain waves, would be around 8 weeks as well. And these are usually met with court challenges, and some restrictive laws that have recently been passed have been overturned by the courts. States continue to pass them as I create this video, and there are certainly more challenges ahead in the courts. On the flip side of that, other states are providing more permissive laws. For example, New York and Illinois in 2019. The state of New York passed what is called the Reproductive Health Act in 2019 and stated that an abortion may be performed within 24 weeks from the commencement of pregnancy, so that allowed that stage to be protected for any reason. Also, if there's an absence of fetal viability at any point, then an abortion could be performed, or at any point when necessary to protect a patient's life or health. Now, the phrase protecting the health of the mother is very controversial because what constitutes a patient's health is not specified in that New York law. Sometimes attorneys have argued that a woman should have a right to an abortion to protect her health because giving birth is a challenge to one's health. So this might even include giving birth in a routine pregnancy. It could include mental health. It could include the mental state of the woman who doesn't want the baby. And so if she's forced to have it, that's harming her mental health. And so basically, roughly, some attorneys end up arguing when you have the clause to protect a woman's health, that basically can apply to about anything. And so you have a right to abortion at any point during the pregnancy whatsoever, including the 39th week. So that's, we have some extreme differences going on among different states. Illinois' laws passed in 2019 actually took back the ban on the dilation and extraction, which there is a federal ban, but now technically in Illinois, it is legal according to Illinois state law And so if by chance that decision could be overturned so that the federal ban would be repealed then or overturned, then it would be legal in the state of Illinois for what proponents or opponents have called partial birth abortion.